Hello friends, welcome to VSP Law channel. Thank you for clicking this video. Today we are going to discuss the judgment of the landmark judgment of the Honorable Supreme Court of India regarding the check bounce case, friends. On point of the legal enforceable debt. So we already discussed about the check bounce cases in our VSP Law channel. If you want to, you can go through the VSP Law channel. Okay, friends. So the case law of the Supreme Court is that Dashrath Bhai Trikam Bhai Patel versus Hitesh Mahendra Bhai Patel 11/9/2022. Recently, a landmark judgment given by the Honorable Supreme Court of India regarding the check bounce case on point of the legal enforceable debt. So, generally, brief facts of the case is that complainant has given a 40 lakhs amount to the accused. So, the accused is a relative to the complainant. So, the condition is that accused has to pay the 1 lakh for 3 months by check, 8,000 in hand. This is a condition. On the condition, amount 40 lakhs amount given by the complainant to the accused. So that accused has paid a part payment of the debt, that is the 20 lakhs out of the 40 lakhs. The 20 lakhs paid to the complainant through the bank. So complainant, without taking the endorsement from the accused about part payment on the issued check, drawn check, the check was presented before the bank for realization. The check was bounced and the complaint is filed a case, check bounce case under section 138 of the INA Act against the accused in Gujarat state. The trial court was acquitted the accused, and the point is that the part payment of 20 lakhs given by the accused to the complainant has not taken any endorsement from the accused regarding the part payment under section 56 of the Act. Without endorsement, the check is present for realization. The check was dishonored. So he filed a check bounce case under section 138 Act. So that the court delivered judgment that without endorsing that the check is presented for payment, the check is not treated as, the check bounce is not an offence under section 138 of the Act, because the endorsement of the endorsement of the check is not taken as per section 56 of the Act. It is clear that the complainant received a part payment from the accused but not taken endorsement on that check presented for the full payment. The check is bounced and filed a check bounce case. The check bounce case was dismissed by the court and trial court and acquitted the accused, released the accused. This was challenged by the complainant as appellant before the Honorable High Court of the Gujarat. So the Gujarat court also be uphold the judgment of the trial court and deliver some points that So the part payment was given by the accused in through the bank transaction that was admitted by the appellant, and but appellant without taking the endorsement from the accused about part payment filed the check before the bank for realization. So the check is dishonored. Such dishonour of check is not a offence under section 138. As because the endorsement under section 56 of the act is not compliant, means not fulfilled. Section 56 of the act says that endorsement must be taken on the drawer of the check, so that Honorable High Court of the Gujarat uphold the trial court and dismiss the appeal. And the matter was referred to the Honorable Supreme Court of India. The Honorable Supreme Court of India, the same Apex Court of India, uphold the judgment of the trial court and summarize the findings. So, as per that findings, the court stated that when a part payment of the debt is made after the check was drawn before the encashment, such payment must be endorsed under section 56 of the act. So this is the finding given by the Honorable Supreme Court. As per we are discussing that it means the check could not be presented without part payment as an endorsement. It means the check could not be presented without endorsement about part payment under section 56 of the act. If unendorsed check is dishonored, the check is not a offence. The dishonored check is not a offence under section 138 of the act, as because such dishonored check is not represented the legal enforceable debt. The next point is that endorsement without endorsement of the payment does not represent the legal enforcement debt. Means legal enforcement debt must be endorsed if about part payment. If there is no part payment, no problem. Debt is represent the legal enforcement. In case of part payment only, the check must be endorsed under section 56 of the act. Such endorsed check is if it is bounced, then section 138 act is attracted, that is offence. If it is not endorsed, there is no offence. Endorsed means about part payment. Remember about part payment. If there is no part payment, no, there is no question of the endorsement. If it is any part payment, there is a question of the part payment. There is a question of the endorsement. Clear that if any part payment made by the receiver of the amount, so accused has to give an endorsement on that back side of the check. So this is that. Clear a conclusion that, friends, In case of part payment, there must be a endorsement. 1 point. And endorsement on the issued check or draw check must be mentioned under section 56 of the Act. If it is satisfied condition of the 56 endorsement made on the endorsement about part payment made on the check is present before the bank for realization. If it is bounced, then is a section 138 of the Act is attracted, unless it is not attracted. So clear that there is no offence under section 138 of the Act if endorsement about part payment is not mentioned on the draw of the check under section 56 of the Act. Clear that. No offence. With no offence if the check is presented without endorsement about part payment. It is not attracting the section 138 of the Act, because it is not fulfill the condition of the section 56 of the Act. Clear that? So this is a landmark judgment. Friends, if any part payment is arise in your cases, then you have to remember this citation. So you can ask that, sir, generally complaint without mentioning that if it is check is presented, whether is needed means compulsory needed. The Honorable Supreme Court has given a direction, must be endorsement regarding the part payment. If the endorsement of about part payment is not taken by the complainant, then loss will be to the complainant because remaining amount will be not get, because as per condition of the section 56 endorsement about part payment is not fulfilled, the check bounce case is not entertained and it will be dismissed. So naturally it will loss to the complaint. Though we can take the endorsement if it is any part payment made by the accused. Remember. So this is the case law, friends. I hope you will get some understanding this judgment. It is very useful judgment. You can take the judgment when the question of the part payment is arise in your case. Thank you for watching this video. Please like, share and subscribe with bell icon, friends. Thank you one and all.